everyone, welcome back to Chapter 8. In this next section, we're going to spend a few minutes talking about the trial process. So in the last lecture, we talked about all of the steps throughout the whole criminal justice system. In this lecture, we're going to talk specifically about the steps that occur at the trial. Okay, so let me share my PowerPoint with you so we can get started. So so the trial is just one step in the criminal justice process. So we went through all of the various different steps earlier. Now we're going to look specifically at the steps of the trial, which is just one step of it in and of itself. So the first thing I want to talk about is criminal trials. When you're talking about criminal trials, you can have two different forms of criminal trials. So you can have what's called a bench trial. A bench trial is where the judge determines if the person is guilty or not guilty. Or you can have a jury trial where a jury determines if the person is guilty or not guilty. So you may ask, who gets to make this determination? The defendant gets to make it because it's the defendant's right to a jury trial. So the defendant could waive that right and just decide to have a judge determine the case if they wanted to, okay? But those are the two different types of trials. Now, when you're talking about trials, you're talking about only about 5% of all cases actually go to a jury trial. So remember, one of the steps we talked about is plea bargaining. In many, many cases, most cases, 95% or more, they're going to be plead and there will be no trial. So these trial steps only kick in if the person would not plea or isn't offered a plea, and they have to actually go to a trial, okay? Now, when we're talking about trials, we have to figure out what constitutional rights are we referring to. So trials are specifically governed by the Sixth Amendment. The Sixth Amendment is a controlling constitutional amendment that governs everything with trials. Now, you don't have to write this, obviously, because you can ask Siri anytime, what's the Sixth Amendment? But it's good to see what the Sixth Amendment says. So it says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. So the first right you have under the Sixth Amendment is the right to a speedy and public trial. And then it says by an impartial jury. So you have a Sixth Amendment right to an impartial jury in the state or district where the crime occurred, or you have the right to be informed of the nature and cause of the accusation. So you have to be told what crime it is you're being charged with and who's making the accusation. You have to have the right to confront witnesses. So we're going to talk about that during the trial. If a witness is called, the defendant has to have the right to ask them questions also, which we're going to call cross-examination. And then you have the right to subpoena witnesses to come testify for you. And you have the right to assistance of counsel, which is an attorney. So these are the main trial rights that you have guaranteed by our Sixth Amendment. Okay, so let's look at the first one. What does it mean to have a speedy trial? What the Supreme Court has basically said is that a speedy trial means no unwarranted delays or prejudice to the defendant. So the general rule is just no unwarranted delay. So the prosecution cannot deliberately try to postpone and delay the trial. Now, to make it a little clear, the federal Congress passed a law that gave specific deadlines. And what they said was, you have 30 days between the arrest and the indictment. So once somebody is arrested, you have to get that formal indictment from the grand jury within 30 days. If not, that's not speedy and the charges should be dropped. Once you have the indictment, you only have 10 days before the arraignment. So before you go back to the judge and they arraign you and you plead guilty or not guilty, it has to be within 10 days that the grand jury passed down the indictment. And then the prosecutor only has 60 days after that arraignment to bring you to trial. Now you might be saying, oh, I know lots of people it took way longer than that. That's because this is the defendant's right to a speedy trial. If the defendant wants more time, they can go to the judge and say, we need more time. Because if you think about it, the prosecutor could wait to arrest and indict until years of investigation. It would be very hard for the defense to put their defense together in 60 days after the prosecution spent years putting it together. So many times it's the defense that goes to the judge and says, we need more time to prepare our defense. So that's why sometimes trials take much longer than the 60 days. It's usually the defense requesting it. Okay. Now we have this thing called statute of limitations. The statute of limitations is the idea that in some instances, the Congress or legislative branch will put a time limit on how long a prosecutor can prosecute somebody for a crime. So if you steal a piece of gum, you can't prosecute you for the rest of your life. After a certain amount of time goes by, a year, 2 years, 3 years, they can no longer prosecute you for those crimes. That's what we call the statute of limitations. It affects the prosecutor. It makes the prosecutor move the cases forward in a prompt manner. Now, why do we have this? Because we don't want the evidence getting stale. Because after years go by, witnesses fade, memories fade, evidence fades, even evidence that would acquit the defendant is going to disappear. So we don't want that to happen. We want the prosecutors to move forward in these cases as prompt as they can. There are a couple crimes that do not have statute of limitations. So in New York, homicides, if you kill somebody, there's no statute of limitations on that. They could prosecute you for the rest of your life. And in New York, sex offenses also do not have statutes of limitations. So there's always the question, should we have it for any? If you commit a crime, should we always be able to even go back and prosecute you for it? But you can see the other side. It's not really fair for the defendant to have that hanging over their heads for the rest of their lives. So that's a statute of limitations. Now, when we talk about the trial, we have to think about who has the burden to convince the jury that the person, the defendant, the suspect is guilty. Who has that burden to put the evidence on their back and carry it into the court and convince the jury of the defendant's guilt? And in our system, it's the prosecutor, okay? So the prosecutor is the one laying the charges. So the prosecutor is the one that has to carry the evidence into court and convince the jury that the defendant is actually guilty of the crime. So we have in our system what's called the presumption of innocence. So think about that. What does it mean to presume someone's innocent? Well, basically, it means that the prosecutor starts from scratch. The jury is going to be told to start with the presumption that the defendant is not guilty. The defendant is innocent. And it's the prosecutor who has to then build the case with their evidence to convince the jury that the defendant is guilty. But the jury is always instructed to start with a clean slate for the defendant and assume that they were innocent. And then it's the prosecutor that has to build the case, has the burden of proof to build the case. So how much evidence do they have to convict a person? What's the standard of proof needed to convict? We already talked about standards of proof in chapter 6. We hopefully remember that, beyond a reasonable doubt. So in order to convict somebody in our trial system, prosecutor has to pile up enough evidence to prove beyond a reasonable doubt that the person committed the crime. Okay. Now, we also have what's called the privilege against self-incrimination. We talked about this in the Fifth Amendment when we talked about interrogation. So remember, with Miranda, you have the Fifth Amendment right to remain silent. That is the privilege against self-incrimination. So how does that play in a trial? So what amendment is that? That's the Fifth Amendment. How does that affect trials? We cannot force defendants to take the stand and testify if they do not want to. So it's the defendant's choice whether or not they want to take the stand, and they can choose not to. A prosecutor cannot force a defendant to take the stand and testify during the trial, okay? And that is all guaranteed by this Fifth Amendment. So the right against self-incrimination is also for interrogations, but it's also testimony at the trial. So what is the right to confront witnesses? Well, if somebody makes an accusation, we believe in our Constitution that the defendant should have the right to ask that person questions and confront that person's allegations. Okay, so we allow this form of questioning in what we call cross-examination. So we'll talk about that when we talk about the steps now. Okay, so let's look at the jury trial. How does the jury trial work? Well, the first thing that's going to happen is there's going to be voir dire, which is going to be picking the jury. Okay, so we talked about jury selection. That's going to be picking the jury. Once we have a jury in place, the next step is that the prosecutor gets to do what's called opening statements to the jury. Opening statements is sort of summarizing what is going to come during the trial. It's kind of your introductory paragraph in a paper where you kind of introduce the reader to what's going on and get them familiar with the facts. That's opening statement. So you tell the jury the facts of the case, what happened, who, what, where, when, how, why. It's written very persuasively. So the prosecutor is going to give the facts in a persuasive way that's going to make you want to convict. And then the defense attorney gets to respond to it after the prosecutor and give their version of the facts. And they're going to tell their version of the facts in a way that makes you want to find the defendant not guilty. So it always goes prosecutor open statement first because they have the burden of proof, and then the defendant gets to give their opening statement. After both opening statements, then the prosecutor has to start presenting the evidence to the jury so that the jury will find the person guilty beyond a reasonable doubt. So the prosecutor presents the evidence. Now, when it's your turn to present your evidence, when it's the prosecutor's turn to present the evidence, they can call witnesses to testify. When you call the witness for your side, so I'm a prosecutor and I call the police for my side, I get to ask them questions, and those questions are called direct examination. So when you call the witness yourself, you perform a direct examination. Now, what's important with direct examinations is you are not allowed to ask leading questions on direct examination. You just have to ask general questions where the person could answer any way they want. Okay, so if it's a direct examination, no leading questions. So you could say, what color was the car, or where was the car going, or how was the car driving? You're not telling them the answer with your question. Once the direct examination is done, don't forget the defendant has the right to confront the witnesses. So the witness then stays and the prosecution sits down. The defense attorney gets to get up and ask that witness questions. That's what we call cross-examination. Now, on cross-examination, you can ask leading questions. Isn't it true that you killed him? Isn't it true that you were speeding? So you can suggest the answer on cross-examination. What you're trying to do is impeach the witness. You're trying to show that they're not credible or reliable or lying or whatever it is, and make that witness look bad in the jury's eyes so that the jury won't believe that witness. So that process continues over and over and over until the prosecutor presents all their witnesses. So prosecutor calls a witness, directs examine them, sits down, defense cross-examines them, sits down, that witness leaves. A new witness comes up, prosecutor directs them, sits down, defense attorney crosses them, sits down. And we repeat that process over and over until the prosecutor has no more witnesses. Once all the witnesses are called, the prosecutor rests their case. Now it's the defense attorney's chance to present their defenses, their evidence of defense. So defense attorneys can call their own witnesses that are good for them and direct examine them, and then the prosecutor would get to cross-examine those witnesses. So it reverses the process. So the defense calls the witness, direct examines them, sits down, then the prosecutor crosses and sits. And we repeat that process until all of the defense witnesses are called. Once they're all done, then we have what's called closing statements. Now, different states do it different. Some states say that, so most people want to go last because they want to be the last voice in the jury's ears. Some people say since the defendant is losing their liberty, they should go last. Other states say, well, no, the prosecutor has the burden, so we're going to give them the last word. So you have to figure out which order that your court is doing it in. But basically, closing statements are your summary of everything that happened during the trial. So they're called summations. So you're summarizing everything that the jury learned, and you're doing it in a very persuasive way. It's your last chance to try to persuade the jury to believe your version of the facts, okay? Once closing statements are done, then the judge is going to instruct the jury on what the law is. So they're going to read the jury the law. They're going to give them rules to follow. They're going to talk about the evidence. They're going to give them standards of proof that they have to find beyond a reasonable doubt. So basically, they're giving the jury all the rules that they have to follow when they're going to make their determination. Then they leave, the jury leaves, and they deliberate and they talk and try to figure out what the verdict should be. Remember, jury verdicts have to be unanimous in this country. So they talk amongst themselves and figure it out, and then they vote. And when they all agree, then they can return to the court and pronounce their verdict to the court. If they find that the person is guilty, then a sentencing hearing will be scheduled, which we will talk about in Chapter 9. And you go to a judge, and the judge will ultimately sentence. If they're found not guilty, then they get to go home. And then don't forget, if the defendant doesn't like the verdict, if they're found guilty and they think errors were made during the trial process, then they can appeal to a higher court to have that higher court review what happened and make sure there were no errors. Okay, so let's talk a few minutes now about evidence. So we said that the prosecutor has the burden to carry the evidence in and prove beyond a reasonable doubt. And the defendant can present evidence to prove why they should not be found guilty. So what are the different types of evidence, or what is evidence? So evidence is anything that can be used to prove the existence or non-existence of a fact. That's all that evidence is. So you're trying to prove either something did or did not happen or exist. So evidence can be any different types of things. Now, what people don't realize is that evidence can be testimony. So when you call witnesses to the stand to tell you their version of the facts, that's what we call testimonial evidence. And testimonial evidence is evidence. People think you have to have real or physical evidence, something that they can touch and see for that to be evidence. But that is not true. People's testimony is also evidence. Now you can have different types of witnesses. A lay witness is going to be a person that just saw what happened and is not forming an opinion. They're just regurgitating the facts to the jury of what they know. An expert witness is going to be somebody that has expertise, schooling, training in a certain field. And since they are an expert in that field, the judge is going to allow that person to give their own personal opinion at the trial. So you can have both forms of testimonial evidence. It's up to the jury to determine if they're going to believe that testimony, but testimonial evidence is evidence. And then we still do have all the other forms of evidence, real evidence, evidence you can touch, guns, fingerprints, blood, DNA, all of that stuff is going to be the real or physical evidence. Okay, so testimonial is the witness statements. Real evidence is that actual physical evidence that you think about. Now, you can also think of evidence, either real or testimonial, can fall into these two categories. So direct evidence is something that establishes a specific fact. Okay, so direct evidence, I have a video showing the woman killing her husband. I have a video. That's direct evidence. It directly proves a fact of the case. So I have to show that the woman killed her husband. Direct evidence, this video directly shows that. Sometimes we don't have direct evidence. We don't have a way to show directly that the person committed the crime. So we can use what's called circumstantial evidence. So we can show that the woman changed her husband's life insurance policy a week before, so she gets $10 million if he dies. And we can show she bought a knife 2 weeks before. Now, none of that directly links her to the killing, but it circumstantially creates a bunch of facts that can lead to the inference or conclusion that she did do it. You can use both kinds of evidence. You don't have to only have direct evidence. If you have lots of circumstantial evidence, all of it piled up, the jury could still find that the person's guilty beyond a reasonable doubt based solely on circumstantial evidence, because having all those pieces of evidence increases the likelihood that it actually did occur. Now, which one do you think would be better if you were the prosecutor? Which one would you want? Clearly, you want direct evidence, but in most cases, you're probably not going to have it. So you will have to rely on that circumstantial evidence. So then the question comes up, can they present any evidence they want, any form of evidence? And there are rules to the evidence that can be presented at trial. In fact, in law school, you take a whole class just on rules of evidence. But these are just some of the most important, okay? So relevance. The judge is only going to allow you to present evidence that is relevant or important to the case. So if the murder occurred inside the house and it's pouring rain out or snowing or a blizzard, who cares? That has nothing to do with the killing. So it's not gonna be relevant what the weather was, okay? It also has to be probative. It actually has to prove one of the requirements. So we're not gonna just allow peripheral evidence, right? Well, 10 years ago, she stole a candy bar from a grocery store. That doesn't prove anything in this case. That doesn't prove she killed her husband in this case. So it has to be something that proves a requirement for this case. It has to be non-prejudicial. So there's some questions sometimes. Should you present colored photographs of a heinous, disgusting crime scene, or is that just going to immediately prejudice the jury against the defendant? So you can't use things that are out and out prejudicial to the defendant. The evidence has to be reliable. So we're not allowing witnesses, experts to testify about anything. It has to be reliable, credible, scientific evidence. And the last thing is the evidence has to be legally obtained. So we talked about the exclusionary rule. If the police obtain the evidence violating people's constitutional rights, it's going to be excluded from trial, and you would not be able to use that evidence at trial. Okay. Now, when we're talking about court system, there is this thing called the CSI effect. The CSI effect is the idea that people watch CSI and they think every case has forensics and the forensics are done in a day and they have all this proof. And that has happened sometimes where juries, if there is no forensic evidence, then they don't want to convict because they think every case should have it. So what are some positives of the CSI effect? It gets people invested in cases and understand about the cases and forensics a little bit more. What's a negative? If you don't have it, it could be detrimental to your case, right? So if you're a defendant and there is forensics, you don't want the jury just to blindly believe everything about it. We could have super bad scientists performing it. So even though there's forensic evidence, it could have been tested improperly. But you may have a bias from the jury that if it exists, then you're automatically going to find the defendant guilty. On the other side, if you're the prosecutor and there is no forensics and the only thing you have is circumstantial, you don't want the jury just to dismiss the case outright just because you don't have it. So there's pluses and minuses to the CSI effect. Now, once the jury reaches a decision, they go back to court and they announce that decision to court. They have different choices. They can find the defendant guilty and convict them. So conviction is guilty, a guilty verdict. If the jury does not believe there's enough evidence to convict, then they find them not guilty, and that's an acquittal. We don't say not we don't say innocent in the system. It's not that they're innocent, it's that the prosecutor failed to prove beyond a reasonable doubt that they were guilty. So not guilty is an acquittal. You can have a hung jury. Remember, all juries have to be unanimous in criminal cases. If all jurors, and they have to agree on either or, they all have to agree guilty, or they all have to agree not guilty. If it is not unanimous, that's a hung jury. So the judge is going to try to persuade them as much as possible to try to work it out. But if they cannot work it out, the judge will say it's a hung jury, declare a mistrial, and the prosecutor will have to make a decision. Are they going to start all over and charge this person again? Now, it's not double jeopardy because there was no conclusion. So that's why it doesn't qualify as double jeopardy. But that's always a prosecutor's choice. Do they think that they could get a conviction if they try the person again? Now, the last couple things I want to talk about is this idea of wrongful conviction. Do you think that there has ever been people that are wrongfully convicted? There are many people in society who don't think it happens, that our system works. And if you're convicted, then there must be a reason why you probably did it, okay? There have been a lot of studies in recent years that show that there's anywhere between 2.3 and 5% of prisoners that are actually innocent. They are not guilty. And one study estimated that 10,000 people are in prison and they were wrongfully convicted of a serious crime that they did not, in fact, commit. So we have to think about what could go wrong that leads to these wrongful convictions. What steps in the process that we talked about is actually contributing to these wrongful convictions. When they did research on it, these were some of the biggest reasons why people were wrongfully convicted. So alleged ineffective assistance of counsel, you have a really bad defense attorney who doesn't do their job and zealously represent their client, so they become wrongfully convicted. Questionable forensics or testimony. There have been different times where prosecutors have tried to use different forms of evidence that have now been proven unreliable. Bite marks is one. They used to be able to think you can match bite marks and that could convict somebody. It has completely been thrown out. There's really no reliable evidence that bite marks can be used. Incentivized witness testimony. So sometimes we have jailhouse snitches where the prosecutor will say, well, if you testify against them, we'll let you out of jail. Okay, so that can be questionable. Forcing people to falsely confess to a crime they didn't commit using extensive, intensive forms of interrogation, especially when people don't have the mental faculty to actually resist that. Prosecutorial misconduct. So sometimes the prosecutor has some evidence that shows that the defendant didn't do it and they hide it and they don't give it over to the defense. Eyewitness identifications. So people's memories are faulty and they pick the wrong person out of a lineup. And then alleged police misconduct. So it could be planted evidence. It could be illegally obtained evidence, wrongful conviction, or exclusion evidence that should have been excluded under exclusionary rule, other police misconduct or error. So those are the different reasons why you could have ultimately somebody that is wrongfully convicted. So just an interesting question to think about. What if you were on trial for a crime? Are you confident that you would be acquitted if you didn't commit the crime? Or would you be nervous that you could be convicted even though you know you didn't commit the crime? So you now know the steps in the system. What are your personal feelings about those steps? Do you think there's enough checks and balances in there to protect the innocent? Because remember, the biggest goal of the criminal justice system is to protect the innocent. We never, ever, ever want an innocent person to go to jail. So it's just an interesting question to ponder. And then the last thing is, what is an appeal? So we've already kind of talked about this. The appeal is the ability of, if you don't like what happened at the trial, you can ask a higher court to read and review what happened at the trial and determine if there were any errors. And if there's an error, the appellate court can send it back and have you be retried, or they can uphold the decision. So those, why is it important to our system? Because it's a check and balance, right? We want lots of checks and balances because we never want an innocent person to be convicted. So what would be some of the consequences if we didn't have this appeal process? You would have a lot more people that could ultimately end up in prison who are actually innocent. Now, once the appellate court reviews what happened at the lower court, they can do different things. They can uphold the decision. So upholding it means that they agree that the trial court did everything correct, and they're going to uphold the conviction. So the defendant will still be found guilty. They can modify it. So let's say that they think the defendant appeals and says they were sentenced too harshly. The appellate court could lower the sentence or modify it in some way. If there were multiple charges, maybe they drop one charge and only fine for one. They can completely reverse it and say, this went so wrong, we're just going to let the person go. Or they can reverse and remand. So they can say, nope, there were mistakes. So we're going to let the trial court retry the person to do it right that time. So those are the different options that the appellate court would have. Okay. Now, I posted a trial practice assessment online. You can go and you can practice and see how you do to see how well you understood all of these steps. Okay, so that's the end of the trial lecture. If you have any questions, please reach out like always, and I'll be happy to answer any questions that you have. See you soon.